All right, PD ready for your arraignments?
Yes,
Judge.
All right, you just call them as you're ready.
Your Honor, first up I have Ms. Natasha Lopez, case number 26-CF-0606. She is present. Your Honor, we acknowledge receipt of a one-count information. We'll enter a plea of not guilty, waive formal reading, and ask to leave this set for the July 13th court date.
Is that correct, Madam Clerk?
Yes, Your Honor.
And there is an offer. I have discussed that offer with her, and we have an appointment scheduled for next month.
All right, thank you very much. Stay in touch with the lawyer. Be back in court on 7/13 unless he instructs you otherwise.
Next, Your Honor, I have Mr. Christopher McDonald. Oh, no, I'm sorry, no. Dylan McDonald. Christopher McDonald already went. Case number 26-CF-0643. Your Honor, we acknowledge receipt of the one-count information, enter a plea of not guilty, waive formal reading, and ask to leave this case set for the July 13th court date. There is an offer, and I have disclosed that. I discussed that offer with my client, and we will be setting a meeting.
All right. Stay in touch with your lawyer. Be back on 7/13 unless you're instructed otherwise, okay?
All righty,
All right, thank you now.
thank you.
Your Honor, I have Nohelia Soriano Martinez. Is here with the interpreter. In 26-CF-431. We are here for arraignment. We acknowledge receipt of the information, waive formal reading, and enter a plea of not guilty.
Has the state extended an offer?
Your Honor, we have attempted to schedule an appointment with the apartment complex that's the other side of the case. And we're in the process of trying to decide how to resolve the case, and we think that we may be able to resolve it without going through, a trial or whatnot. So we're not at the position yet to extend a formal offer.
7/13, Madam Clerk?
It looks like this case has not been previously set, but I can set it for 7/13.
7/13, please. Please stay in touch with your lawyer and be back on court on the 13th of July unless you're given instructions otherwise.
Está bien, señor juez, y pido su palabra, por favor.
That's fine, Your Honor, and if, may I say a few words?
Well, speak to your lawyer first. I'll turn this noise on, Madam Court Reporter, Madam Interpreter, if you...
It's okay. Actually, I've spoken with my client and advised her to not speak about the facts of her case at this time. I believe she's still seeking to refer to the court.
Si él me lo permite.
If you allow that.
As long as you don't discuss the facts of the case and you follow the advice of your lawyer.
Okay. No. No puedo hablar, entonces.
I'd like to say a few things that, actually there's a couple points that I believe that are important for you to have knowledge of, and I'd like to discuss them.
Once again, follow the advice of your lawyer. Do not discuss the facts of the case. The state attorney is present. There's a recording being made. If you discuss the facts of the case, anything you say may be used against you in the prosecution of this case by the state against you.
Comprendo, pero debo dar a conocer que soy inocente y que las evidencias se presentaron ante mi abogada y la señora acusadora Jennifer Harris está dando largas al asunto porque son 2 semanas que ella va a estar fuera.
So I understand that. I just wanted to let you know that I'm not guilty. My attorney has proof of that. The accusing party, Ms. Harris, she's just extending this process longer than it needs to be.
Y yo padezco de ansiedad.
And I have anxiety.
Esto me ha generado muchos problemas en mi enfermedad. He retomado mi medicamento para poder dormir.
This is generating even more issues. I've had to initiate my medication treatment again so that I'm able to sleep.
Los cargos que me han entregado hoy son falsos. Yo mantengo las evidencias donde la señora Harris ha hecho varios delitos en mi contra.
The charges that were presented to me today and the information are not true. I have evidence that Ms. Harris is the one that has been committing.
Yes, ma'am. We really shouldn't get into this. Today is not the day that we try the case. Today is a procedural point in the case where you're presented with the formal charges. With the assistance of your lawyer, she will help you collect the evidence that would be necessary to present to the state regarding your defense. But today is not the day for that.
Está bien y gracias por escucharme.
Thank you, and thank you for listening to me.
Yes, ma'am. Good day.
I have one in-custody client, DeBaron Smith.
Say again?
DeBaron Smith.
Smith.
He's set for the 2 p.m. docket, but if you'd want to go ahead with people in the gallery, I'm okay with that.
Yeah, let's get the folks in the gallery before we get to our detained folks. I show with Mr. Cochran, a couple of others, and I guess you as well, Ms. Yeski, you have a couple of other folks in the gallery, or that should be?
Yes, Your Honor, I just need to extend a couple offers, and then the PDs will be ready. If you want to go through the docket of people who don't have a lawyer appointed.
Okay, let's do that, then that'll give you a chance to chat with your clients.
Thank you.
James Mayberry, please. So information from Mr. Mayberry. You're here today, sir, without an attorney. Do you wish to have an attorney represent you?
Yes, Your Honor.
Are you able to afford one on your own?
Not currently, Your Honor.
All right. What copy of the application for the appointment of public defender will be provided to you? If you'll complete that, don't leave until you turn it in and get a new court date, okay?
Yes, Your Honor.
All right, thank you. Enrique Mendoza Martinez. Good afternoon.
Good afternoon, sir.
You're here today without an attorney. Do you wish an attorney to represent you?
No, thank you.
You don't think you need a lawyer to help you?
No.
Do you understand the charges against you?
Yes, sir.
Okay, does the state have an offer to make in this case?
Yes, Your Honor. It would be either an adjudication of guilt, 60 days in the Okaloosa County Jail, or a withhold with 18 months probation, 24 hours of community service work, and then a substance abuse evaluation and any treatment recommended.
Do you understand what the state is offering?
Yes.
Is that something you feel comfortable doing
Yeah.
without a lawyer?
Yes. Preferably lawyer.
Okay. Can you afford a lawyer on your own?
Say again?
Are you able to afford hiring a lawyer on your own?
No, not right now, sir.
Okay. A copy of the affidavit for the appointment of the public defender will be provided to you. Complete that and turn it into the bailiff. Don't leave until you get a new court date and you turn your form in, okay?
All right, sir. So we're calling him back?
Yes.
Okay. Fill out the paperwork and then come bring it back up.
Angela Miller. Good afternoon. You're here today without an attorney. Do you wish an attorney to help you?
No, sir.
You don't believe you need an attorney to represent you?
No.
Do you understand the nature of the charges against you? Here's a copy of the formal charges against you.
Yes, I do.
Does the state have an offer to make in this case?
Yes, Your Honor. It would be either an adjudication of guilt, 60 days in the Okaloosa County Jail, or a withhold, 18 months probation, 24 hours community service work, and a substance abuse evaluation and the treatment recommended.
Do you understand that?
Yes, sir.
Are you willing to do either one of those?
Yes, sir.
Which one do you want to accept?
The probation.
All right. Do you feel comfortable you can do that and understand what those terms and conditions are without the help of a lawyer?
Yes, sir.
Okay. Have you done this before?
No, sir. But I do understand.
Judge, may I approach as a friend of the court?
Yes, you may. All right. With Mr. McKinney's assistance, do you understand the terms and conditions?
Yes, sir, I do.
Mr. McKinney, are you in a position to assist by writing out a plea for
I
the...
can certainly do so.
All right. I require the pleas to be in written form. That way you can see exactly what the terms and conditions are, and they'll be all written out for what it is that you're pleading to.
Yes,
Mr.
sir.
McKinney will help you by completing that if you'll have a seat, and then we'll call you back and accept your plea, okay?
Okay, thank you.
Jessica Miller. I'm sorry, Miss
I have
Yeski.
one case to call. We could call DeAndre Seymour Short in 26 CF 692.
All right.
Mr. Short is approaching. We acknowledge receipt of the information, waive formal reading, and enter a plea of not guilty to the charges.
7:13?
That would be great.
Okay. Stay in touch with your lawyer and be back in court on 7:13 unless your lawyer instructs you otherwise, okay?
Yes, sir.
Okay,
you.
thank you. All right, Jessica Miller, please. All right, good afternoon. You're here today without a lawyer. Do you want a lawyer to help you?
Yes, sir.
All right, you able to afford one on your own?
No, sir.
All right, here, a copy of the application will be provided to you.
Okay.
If you complete that and give it back to one of the bailiffs, don't leave until you turn it in and get a new court date, okay?
Yes, sir.
All right, thank you.
Thank you.
Angelo Ruiz. Angelo Ruiz. And clerk, assist me by checking notice, please.
What's that case number, Your Honor?
It is 26 CF 654.
Looks like a written plea of not guilty was filed on 5/12, Your Honor.
All right. So it just didn't make it off the docket. All right. And who's this attorney?
Jay Patel, Your Honor.
Okay. 512, you say?
Yes, Your Honor. It looks like it's a docket entry number.
Set for 7:13.
Yes, Your Honor.
Okay.
Okay, great, thanks.
And Ms. Yeski, if you're ready with DeBaron, oh, I think that's all of our unrepresented on the 1:30 docket. So if the PD has anyone else on 1:30, or I can take anyone who's ready on the 2 o'clock docket. All right, silent. Silence those phones.
Silence your phones and watch it, please. Thank you.
Double check mine. Okay.
Your Honor, I just want one more defendant listed as pro se. 26 CF 614, Mr. Ortega.
Ortega. I don't show him on my docket. Yeah, Christopher Ortega.
Yes, Your Honor.
Christopher Ortega. Ortego.
Your Honor, I have one more to call from the gallery.
All right, hold on just a second, Ms. Yeski.
Okay.
State on Ortego, I see proper notice, it appears. He's on pretrial supervision. With weekly check-in in person, but I don't see the defendant present today. What's the state's desire?
KP, Your Honor.
All right, issue capias, Madam Clerk.
Yes, Your Honor.
I'm sorry, Ms. Yeski, go ahead.
We have Sean Phillips.
Phillips, please.
Approaching in 26 CF 727. We have the information, waive formal reading, and would enter a plea of not guilty.
All right, is there any offer from the state?
There is. I can announce it. It's a withhold of adjudication, 2 years of standard probation, 24 hours community service work, complete a substance abuse eval and any recommended treatment, court costs and costs of defense, or an adjudication of guilt and serve 60 days in the Okaloosa County Jail. Mr. Phillips just needs a little bit of time to meet with me at my office. I've given him my card, and we will have that meeting.
Okay. All right. Get in touch with your lawyer, and then we'll see you back on 7/13 unless your lawyer instructs you otherwise, okay?
Thank you.
Thank you. Have a good day.
Judge, we're ready to recall Ms. Miller.
Ms. Miller, please.
Ms. Miller is here in 26 CF 677. I'm standing in this front of the court. May I approach her before?
Granted. All right, Ms. Miller, would you raise your right hand, please? Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay. Now, Mr. McKinney's acted as a friend of the court and filled out the form, but you're not represented by him. He's simply assisting the court in completing the form. How old are you?
61.
How much school do you have?
High school graduate.
All right. You able to read and understand the plea form?
Yes, sir.
All right. And did you do that before you signed it?
Yes, sir.
All right. According to this plea form, you're pleading no contest to the charges, and the sentence will be 18 months of probation with special conditions of evaluation, recommended treatment, and community service hours, and there'll be testing as well to confirm that you're substance-free. Adjudication will be withheld, and you'll have the fees and costs that are written in the plea form. Is that what you understood?
Yes, sir.
In addition to those special conditions, all the standard conditions of probation which were listed in the agreement would apply to you as well. Do you understand that?
Yes, sir.
All right. Have you ever been on probation before?
A long time ago.
Okay. So do you understand by this plea agreement that you're pleading no contest to the charges?
Yes, sir.
And that tells me that you believe the state has the evidence necessary to prove to the jury your guilt of the charge of possession of a controlled substance.
Yes, sir.
Do you understand by pleading no contest, you're waiving your right to a trial by jury where the state would have to prove your guilt of this charge beyond a reasonable doubt to that jury?
Yes, sir.
Adjudication will be withheld as we discussed. You're going to be on 18 months of probation with the conditions that we discussed. Did you understand that?
Yes, sir.
And the fees and costs that were involved. Do you have any questions about the plea arrangement that hasn't been asked?
What is the cost of supervision since I'm unemployed right now?
Say again?
The cost of supervision because I am unemployed right now?
Okay. Do you anticipate becoming employed?
Yes.
Okay. I'll waive the cost of supervision, and I'll make a provision that in addition to these conditions, then you should be looking for a job.
Yes, sir.
And that the cost of supervision will remain waived until you've been employed for 90 days.
Yes, sir.
Okay? Anything else?
No, sir.
Okay. The court will find the plea to be freely and voluntarily entered into. I'll accept the plea. Okay. Now check in with probation before you leave. They'll give you some instructions about what you need to do, about reporting to them and getting processed in. Okay?
Okay, thank you.
All right. Thank you. All right. James Mayberry, please. I've reviewed your form. It appears you qualify for the public defender, and I'll appoint the public defender. The one question I did have is you indicated down here on the bond, you were released on bond. Did you do that, or did your family help you do that?
My family did that,
Okay.
Your Honor.
And so I'll appoint the public defender to represent you. This is James Mayberry, 26 CF 663. I think he already got the information, I think, Mr. Cochran.
You already have the information? Yes, sir. Your Honor, Attorney Christopher Cochran, on behalf of Mr. Mayberry, sorry. Your Honor, we'd acknowledge receipt, waive formal reading, enter a plea of not guilty, and ask to leave the set for the July 13 court date.
All right. Is there an offer?
Not at this time, Your Honor. We're awaiting restitution amounts with the victim's Your Honor. But it will be a probation offer. I do know that.
All right. So, Mr. Mayberry, stay in touch with your lawyer. Be back in court on 7/13 unless your lawyer instructs you otherwise. You've heard what the state says. It seems the principal issue for the state is restitution. And if they get that information, then Mr. Cochran may pass it along to you, and you may need to be back in court before the 13th to resolve the case, okay?
Yes, Your Honor.
Okay, thank you.
I'll just call my office and make sure.
And I have C-lock on the arraignment docket, but I believe we took care of them earlier, right?
Yes, Your Honor.
Okay. Jessica Miller, please. All right. And now, I'm reviewing your form and everything. I understand, however, you indicated down here, you actually were released on a cash or professional bond, not a cash bond. You checked cash.
Oh, I'm sorry, professional.
So, but the amount you put there was the amount that would have been
I
paid.
paid cash, yes, sir. It was supposed to be 2,000, not 200.
Right. And did you pay that, or did your family or someone
I
else?
did.
Okay. So that's actually a surety bond.
Okay.
And you paid the bondsman the premium.
Yes, sir.
Okay. All right. It appears you do qualify. I'll appoint the public defender to represent you in this case.
Thank you, sir.
Hold on just a second, Mr. Cochran. Go ahead, Mr. Cochran.
Your Honor, Mr. Cochran, on behalf, I would acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the July 13th court docket.
Is there an offer?
Yes, Your Honor, it's adjudication of guilt, 2 years probation, $15.71 to Aldi, 48 hours community service work, no trespassing to Aldi.
All right. Be back in court on 7/13. Stay in touch with your lawyer unless you're, and be back in court on 13th unless your lawyer instructs you otherwise, okay?
Yes, sir. Thank you, sir.
Okay, thank you.
Call my office.
Yes.
All right, so I show Genesis Mendoza with you, Mr. Cochran, and then Lilani Whitson with Mr. McKinney, but I thought we took care of that, didn't we?
We did, Judge. We set that over on to Monday, and I entered a plea of not guilty for Ms. Whitson.
Right,
Correct.
right. Both the cases, the existing case and this new case, were set over to docket day.
Correct.
Your Honor, I have not met Ms. or Genesis Mendoza. I have not seen a person respond to that name in the courtroom.
They would request a KP, Your Honor.
Well, let's check notice first, okay? Yes, it appears that the bond, in fact, instructed the defendant to appear today. Issue a capias, Madam Clerk.
Yes, sir.
And my office would have been moving withdrawal anyway, so if it comes back. That's all I have for that docket, Your Honor.
All right, and then I showed just the Enrique Mendoza Martinez left. We completed that application yet?
He's finishing that now, sir.
Okay. All right. Anybody on the 2 o'clock docket ready to roll?
I have an in-custody person.
Say again?
I have an in-custody client.
Okay.
There you go. Your Honor, this is DeBaron Smith before the court in 21 CF 1470, 19 CF 431, as well as 26 CF 61. I know that this is set for a contested hearing today. However, I've spoken with the state and we are requesting a continuance to the June miscellaneous date, and that would be without subs.
Correct, Your Honor, please.
Do we expect that that will be a resolution on that day?
I don't believe so. If you wanna, I think.
Please approach.
Friday from 10 a.m. till 4 p.m. and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
All right, 611, no subs.
Thank you.
All right. All right, Mr. Mendoza-Martinez, please.
Yes, sir.
If you're done, yeah.
All right, the same with you. You actually posted a surety bond of $2,000. Did you pay the bondsman, or did someone else help you do that?
Somebody else.
Okay. All right. And you've indicated your take-home pay is that's your income yearly, is that right?
No, it's monthly.
It's monthly,
Yes.
and that's what you take home?
Yep.
Okay. All right. I'll find that you do qualify. All right, so you listed your car. But it seems like you indicate you owe money on the car as well, right?
Yes.
All right, so the amount you listed on the car, is that after you take into consideration the liability?
It's I was thinking so. Yeah.
So, all right. I'll find you do qualify. I'll appoint the public defender to represent you in this case.
Okay.
Yes, Your Honor. Attorney Chris Cochran on behalf of Mr. Mendoza-Martinez. We enter a plea of not guilty, acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the July 13th court docket.
Is there an offer from the state?
Yes, Your Honor, an adjudication of guilt, 60 days in the Okaloosa County Jail, or a withhold, 18 months probation, 24 hours of community service work, substance abuse evaluation, and any treatment recommended.
All right. Stay in touch with your lawyer and be back on 7/13 unless your lawyer instructs you otherwise, okay?
All right, sir.
Thank you now. Good day.
Judge, may I approach with Ms. Leonard?
At Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Judge, may I call Thomas Cole?
Yes, sir.
Do you have any questions for me? No. Judge, Mr. Thomas Cole is before the court in 23 CF 851. This is on the docket for sentencing. However, we have been able to reach an agreement with the state. And the terms of that agreement would be to admit to the violation of probation. He's previously done so by the admission to the court. And the sentence would be reinstatement of his supervision to complete the original requirements with the additional $100 VOP fee, $150 cost of defense. The added modification would be an 1129 in the Okaloosa County Jail with credit from the date of the VOP arrest. Would be the only change to the sentence. The original requirements being reimposed would include the 10-year suspended sentence, which was imposed at the time of the plea. May I approach with, I wrote a new plea agreement, given that there was a change in terms. And I don't want to muddy the record, but I did want to make sure that that was reduced to writing. May I approach with that agreement?
Granted. And so the court understands the state is agreeing to the defendant withdrawing his prior plea and substituting this plea agreement in lieu of the prior agreement and waiving the sentencing hearing that was deferred till today in return for this plea agreement.
That's correct, Your Honor.
Okay. All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay, and you can put your hand down.
Thank you.
Now, you heard that discussion that I just had with Mr. McKinney and with Ms. Leone regarding your prior plea agreement and the fact that you're here for sentencing today, and that they're agreeing to withdraw the prior plea agreement and substitute this one that you've just signed with Mr. McKinney. Is that what you understood?
Yes.
And this plea agreement has you also admitting the violation. Do you understand that?
Yes.
And that says to me that you do agree that you violated the way your officer says you did. Is that right?
Mm-hmm.
Have to say yes or no.
Yes.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes.
And you were previously adjudicated in this case. You'll be reinstated and modified to include a sentence of 1129 in the county jail with credit for time served, but that credit is only from your arrest on this VOP. So you're waiving any prior credit for any arrest prior to the VOP that we're sentencing, that we're accepting the plea for today. Do you understand that?
Yes, sir.
That's important because ordinarily you're entitled to all credit for time served. The way the court reads this plea is the state is making your waiver of that credit for time served a condition of this plea arrangement. Do you understand?
Yes.
Now, that doesn't constitute a waiver for any credit for time served. If there's anything else in the future, it's only regarding this 11-month 29 sentence on this plea arrangement. Do you understand?
Yes.
Okay. And then you'll have the additional fees and costs for the violation and the cost of defense. And the plea agreement emphasizes that this does not discharge or do away with the suspended sentence that remains a condition of your probation.
Yes.
So by the state agreeing not to impose the suspended sentence by this plea agreement does not mean the suspended sentence goes away. It is still there in a subsequent violation if the state seeks to impose it. Do you understand?
Okay. Yes.
Okay. Mr. McKinney, answer your questions about the plea and how it affects you?
Yes.
You satisfied with how he's represented you?
Yes.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. All right, Mr. Nopes, and I guess that, who's with Jaden Lovett?
Yes, sir. So, Judge, Dr. Harper is going to appear via...
She is in the waiting room. I'll let her in now.
Yep. And Judge, for the record, this is 21 CF 206.
And who for the state? Who's representing the state in this case?
I am, Your Honor, Salvador Gomez for the state.
Good afternoon, Dr. Harper. Are you able to hear us?
Yes, Judge.
Okay, good. We ready to proceed?
Yes, sir. Yes, Your Honor. We call Dr. Harper.
Dr. Harper, if you'd raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
You may proceed, Mr. Nopes.
And just for the record, state your name
Dr. Julie Harper.
and what licenses do you hold in the state of Florida?
I'm a licensed psychologist in Florida.
And do you see Jaden Lovett standing next to me?
Yes, I do.
Okay. Did you do a report that involved Mr. Lovett?
Yes, I generated a report after seeing Mr. Lovett for 2 evaluation sessions.
Your Honor, if I could approach the court.
Granted. state had the benefit of the report?
Yeah, we've reviewed the report, Your Honor, and we have no objection.
All right, very good. Has it been previously filed, Mr. Nopes, or are you tendering it now for filing?
Judge, I thought about that on the way down, and I didn't get a chance to look. I don't know if we did notice of confidential filing. There's always those people in the background that's running around doing stuff for you, but I don't remember if we filed it or not.
All right. I'll check now, Mr. Nopes. Let me see if I can.
You're rubbing it in that you can actually see stuff on the clerk's website.
I don't see that it was filed. I'll tender it to Madam Clerk in all of the cases and direct it to be placed in the non-public section of the file, Madam Clerk.
Thank you, Judge.
And for purposes of the hearing, we'll mark this as Defendant's Exhibit A.
Okay. Thank you, Judge. So, Dr. Harper, did you prepare a report, I guess the date is May 7th of 26th?
Yes, Mr. Nopes, I created a report. I also sent a corrected copy to your office today after I noticed that I had included, unfortunately, 3 typos in the report. So your office received a corrected copy today, changing one area was his age, and then from a template, there was a Scrivener's error where another person's last name was carried forward from the template. So I corrected that back to Mr. Levitt's name.
And so, Dr. Harper, I had already left Crestview and you sent that. Could you just tell us briefly where those changes need to be made?
Absolutely. So the mental status examination is a section of my report. It is section 5, and that is on page 4. There was an error of his age. At the time that I saw Mr. Levitt, he was 26 years old, so I changed it from 19 to 26. And then on page 5, I use a template for writing up my IQ results, and there was an error there. So there is a different name in the template. The results are correct. These are Mr. Levitt's IQ scores, but unfortunately, there's a wrong last name that's included in that paragraph.
Would that be, I think it says Mr. Burns?
That's correct, yes. So that is just part of a template, and so I do apologize that those errors were forwarded to your office, and I tried to correct that today.
Okay, and those are the only changes?
Yes, sir.
Okay. As a result of your involvement with Mr. Levitt, did you find that he suffers from a mental health issue?
Yes, actually, he has several different conditions that are co-occurring at one time. The mental health diagnoses that I identified included major depressive disorder of a recurrent nature. At different times, it's at different levels of severity. During this time that I saw him in the jail, it was mild, but it has been more severe in the past. I also diagnosed him with borderline intellectual functioning, and that is related to his current level of cognitive ability. Included a rule-out, meaning under consideration, something that time will tell if he goes on to meet full criteria for a schizophrenia spectrum disorder. He had some symptoms present at this time, but I did not find that he met the full criteria on the days that I met with him. Because of the complexity of Mr. Levitt's cognitive issues, I included under consideration rule-out diagnoses of mild neurocognitive disorder due to head trauma, and that is because he was, of course, in this sequence of events that led to his arrest for this case. He was ejected from a motor vehicle and had a head injury. So that is under consideration versus intellectual disability. And there is evidence that was presented to me of his being deemed disabled, and so I do think it is possible he met criteria for intellectual disability in his youth. And since that differed a little bit from my IQ testing presented at this time, that's left as a rule out or under consideration. I didn't have access to his childhood scores, so that determination could be made more fully if those scores were available. Additionally, cannabis use disorder and sustained remission, and a rule-out consideration of alcohol use disorder. Those were all symptoms that were present at the time that I saw him.
Okay. And do you believe that he needs some specialized treatment to focus on correcting some of these disorders?
Yes, he does. So prior to the case events, Mr. Levitt described, the onset of his mental health symptoms, which in his preteen years included depressive symptoms and quite a bit of anxiety. And the reason that I'm pointing that out is that, these are kind of early onset childhood mood disturbances, and they're related to things that he went through in his childhood, including, family poverty and the breakup of his family, and, sadness and anxiety that he had related to just wondering if his basic needs were going to be met on a day-to-day basis, and having other children, basically bully him for his poverty and things that really stood out to them as differences. That stuck with him, and even though some of the depression resolved to a degree, when he again started experiencing things like housing stress, some difficulty with his child's mother, relational problems, the depression reoccurred, and as he explained it, he was in a very dark time or having deeper depression prior to the incident. When a person has this sort of baseline level of mood disturbance, they don't necessarily realize that they lack coping skills for these types of problems, or that they could be treated. So I do think that Mr. Levitt would really benefit from learning better management of his mood condition. He's going to need individual therapy for that because of his lower cognitive ability. I don't think that a group format would really address, some of these early childhood issues or depression at the level that he would benefit most. He needs things explained in more simplified language, and I do think that an individual therapist who's, skilled in those areas could really help him. I think that he would benefit from that. So that would be the specialized treatment for the mood disorders specifically.
And do you believe that he is agreeable or amenable to receive that specialized treatment and counseling?
Yes, I do. One of the reasons that I believe that is that he described to me the changes that he's undergone since being in the jail or during incarceration. Essentially realizing that his earlier way of thinking about things was immature, and that he was not really coping with the stressors in his life well, versus his way of thinking about things and wanting to shape a better future for himself and his son. And so I do think that that's motivating, and he didn't have that level of abstraction or kind of sitting back and looking at his life that he has now.
Okay. Your Honor, I don't have any further questions for her. I tender the witness.
The state has no further questions for this witness, Your Honor.
Is the witness released?
She is, Your Honor. We'd ask to introduce that report.
Objections to the admission of the report?
Nothing from the state, Your Honor. No objections.
Thank you, Dr. Harper. You're released.
Thank you, Dr. Harper.
Thank you. Goodbye.
And so, Judge, as it pertains to the sentencing today, I got him evaluated so the court would have that extra information to fall back on. But our agreement with the state is that he would be sentenced as a youthful offender, I believe.
I'd stated that we wouldn't necessarily object to that, but that this was going to be an open plea and we would be able to make our arguments, but that the court has every right to sentence him as a youthful offender if they agree to that.
So Judge, we would ask the court to find a mitigator was proven, and then for the court to consider sentencing him to youthful offender.
State?
Are you asking for our arguments in terms of what the sentence should be at this time? Or?
Yes, you're passing it to the state this time,
I just
Mr.
want to make
Noakes?
sure that I'm aware.
I'm sorry, Judge?
You passing it to the state at this time?
I am, Your Honor.
Yes, go ahead, Mr. Collins.
Your Honor, at this time, the state would like Ms. Monica Caldwell to be able to speak, Your Honor.
And you can have a seat at council table, Mr. Noakes, with your client, please. Yes, on the stand. Good afternoon. If you remain standing and raise your right hand, the clerk will administer the oath to you.
I swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Thank you.
Please be seated. Can you see that microphone right there in front of you?
Yes, sir.
Direct your voice to the microphone and speak clearly and distinctly for us.
Okay.
It's important we can all hear you.
Yes, sir.
Also, there's a court reporter way in the back of the courthouse taking all of this down, so it's important they're able to take it down and make a good record, okay?
Yes, sir.
And if one of the lawyers objects, stop speaking until I give you an instruction how to proceed. Is that okay?
Yes, sir.
All right, Mr. Go, and if you need a break, you just let me know and we'll take a short break for you, okay?
Yes, sir.
Mr. Gomez.
Thank you, Ms. Caldwell, for being here. Can you just please state your name for the record?
Monica Ann Caldwell.
Okay. And how are you related to this case?
My son Javon Bryant was the child that was killed.
And I believe you wanted to let the court, you wanted to speak in front of the court today?
Yes, I did.
All right, please do that.
First of all, I just heard the mental whatever decision with him. But to let you know, you made a decision back then that changed my life. You want the court to plead on you because you got a child and all that? I don't want that. You don't deserve that. Because then you didn't deserve to take that time out to pull that car over. You made a conscious decision to keep going, which cost my son life. You are still here. He's not. 5 years later, you made that decision for my son. You got to have a child. Share moments. You get to pick up the phone, call your mom. She get to hear your voice again. I don't. Hate, I don't, but I can't forgive. I will never forget. If you was a friend of his, you would never friend. I never got the chance to see my son walk across the stage, get his first job. Who knows where he could be now, 5 years later? He was only a child. He was only a child. So with that being said, I want you to wake up every day seeing my son's face. Because you made that decision to take his life because you could have stopped that car. You out here breathing air. You get to wake up. He don't. You get to pick up the phone and talk to whoever you want to talk to. He don't. But you here to ask the court to show mercy on you. You didn't show mercy on us. So I hope the court find it in their heart not to be leaning on you, no matter what you got going on. Because at that time, you didn't care. So now this time, I don't care. You need to pay for what you did.
No further questions, Your Honor.
Mr. Noakes, you wish to inquire?
No, sir, Your Honor.
The state has no further witnesses, Your Honor. The state proceed with argument, Your Honor.
Judge, my client has just indicated that he'd like to make just a very short statement.
Hold on just a second. I'm unclear in reviewing the progress docket and reviewing the addendum probable cause and the circumstances. If you'd approach. All right, so the defendant wishes to elocute.
I'm sorry?
The defendant wishes to make a statement?
Yes, sir.
Okay. Yeah, at the lectern. You
yes.
want to speak to him first?
No. Make sure you speak into the microphone, okay?
Yes, sir. Judge Stones, I want to admit that I apologize if I've been, I just want to say sorry. I mean, like, I pretty much don't know how to put it in my own words, but I'm sincere sorry for all the pain that I brought upon.
I
don't know her name, but I just want to apologize, and I'm sincere sorry for the pain that I brought upon her and her family. I don't know her name. I don't remember her name. I can't remember.
Is it Javon's?
Javon Bryant.
Is it? Yes.
But I want to admit that I'm sorry, and I apologize for all the pain that I brought upon her.
All right. State wish to resume?
Yes, Your Honor. Is it all right if I speak from here?
Yes, sir.
Your Honor, we are here today to sentence Mr. Jaden Lovett. Just to remind the court or refresh the court's recollection, he pled to 2 counts of fleeing and attempting to elude with serious bodily injury or death, 1 count of vehicular homicide, 2 counts of DWLSR with serious bodily injury, which is a 3rd-degree felony. So we have 2 first-degree felonies and a second that really is the focal point of the sentencing. As currently charged, he scores 78.9 months, and the Department of Corrections is the lowest permissible guideline sentence, with a maximum sentence, given all of those counts, of 88.15 years. I believe it's the defense's intent to ask for youthful offender status. The state is respectfully going to request that not be given. The state respectfully requests that this individual, this defendant, be sentenced to 10 years in the Department of Corrections. The reason being is that when you look at the report in this incident, Your Honor, yes, he was young, but he was 20 years old. When you look at the individuals who were in that car, they are ages 18, 17, 15, and Mr. Bryan at the time of this incident, who was no longer with us because of this incident, was 16 years old. Mr. Lovett was, by all accounts, the most mature individual in that vehicle. This all could have been avoided had Mr. Lovett chosen to just pull over. But he did not choose not to just not pull over. He chose to speed up. The report stated that there were speeds as high as 140 to 150 miles per hour, and he was weaving in and out of traffic. We see, I think it was the Kia, which was a stolen vehicle at the time, overturned for approximately 360 feet, according to the report. And the individuals in that vehicle were all ejected from the vehicle. To be quite honest, I think Mr. Lovett is very fortunate that he's not sitting here with multiple cases of vehicular homicide from that incident. As we heard from Ms. Caldwell, I think it goes to the crux of why the state is asking for this sentence. She does not get the ability to speak with Mr. Brown. She didn't get to see him walk across that stage, didn't get to see him take his first job. And even as Mr. Lovett here is able to go forth and father a child, she never gets to meet what could have been her grandbaby at some point in time in the future, Lord. And so this isn't a situation where if Mr. Lovett even deals with this for 10 years, that Miss Caldwell and her family would only have to endure this for 10 years. They're going to have to endure the pain and the consequences of Mr. Lovett's choices for the rest of their lives. And I just want to note that that his brother and sister are also present in this court. They are going to have to endure that for the rest of their lives. And so the state feels as though this sentence should reflect the seriousness of the choice that Mr. Lovett made. I will acknowledge that when you look at the defendant's criminal history, it seems as though approximately 5 days before this is when he got the extent of the rest of his charges that are listed. All the 20 CF cases that we see occurred approximately 5 days before this. So the state acknowledges that it appears that his criminal history is somewhat tied to this probably week of very poor decision making by Mr. Lovett. But I want to highlight that all of these decisions were adult decisions. He was 20 years old at the time of these offenses. And I don't think that it can be stated enough that when he was in that car, he was the oldest individual in that car. He should have known to have pulled that vehicle over the second that trooper lit his lights up. But instead, he decided to prolong this pursuit for 5.4 miles. I can't tell you how many thoughts we can have in 5.4 miles, but every single time that he had a thought, he chose not to pull over that vehicle. He chose to speed up, and he chose to travel almost, I think, over double the speed limit at that time, Your Honor. Your Honor, for those reasons, the state is respectfully going to request that we do not sentence this defendant as a youthful offender and that we sentence him to 10 years in the Department of Corrections. However, if this court does feel, given the report and given what we've heard here today, that a youthful offender status would be warranted in this circumstance, the state would respectfully request that he be sentenced to the 4 years in the Department of Corrections followed by 2 years of probation. I do want to point out, and this is just in reference to the report that we saw, Mr. Lovett actually reported, because I think the primary issue in this report would be the major depressive disorder. He reported that he had just begun to realize these positive feelings of earning income when he was arrested for these charges. And so I think it speaks to his actual mental state at that time and whether or not he was actually affected in that moment by the things that were discussed in that report. So Your Honor, respectfully, the state requests 10 years in the Department of Corrections, but if this court does deem that youthful offender status is necessary or warranted in this situation, we would request 4 years in the Department of Corrections. I also think it should be noted that for quite some time the defendant was out on bond, and then the reason why he's back in custody is because of some alleged new law violations that occurred over in Jackson County. And so I think the court should also take that into consideration when considering this consequence and the punishment that the court is going to sentence him to. Thank you, Judge.
Mr. Nopes, any follow-up?
Judge, we believe that we proved the mitigator of a mental health issue for which he needs specialized treatment, and that he's amenable to that treatment. Judge, what I'm asking the court to do is just to sentence him as a youthful offender and give him 2 years in the youthful offender camp, followed by 4 years of probation. Now, I believe he's got a lot of time in as well, based on this case got handed off and handed off and handed off, and I think Don Whitmire had it prior to me. But you know, it is a 2021 case, but we would ask the court to consider sentencing him as a youthful offender, and 2 followed by 4 years of probation. That's our request, Your Honor, and of course, give him credit for all time served against whichever sentence you come up with.
Anything else?
Yes, sir, Your Honor.
The state and the defense had the benefit of the PSI.
Yes, Your Honor.
Yes, Your Honor.
Any changes, amendments, or alterations, or challenges to the contents?
No, sir.
Nothing from the state, Your Honor.
Okay. According to Trooper Valentine, moments before the crash, he was traveling northbound on State Road 85, measured the southbound Kia speed at 95 miles per hour in a posted 65 mile per hour zone. He also witnessed the Kia changing lanes while passing other vehicular traffic in a reckless and erratic manner. In response, Trooper Valentine made a U-turn, proceeded southbound on State Road 85, and began to overtake the Kia. In response to Trooper Valentine's emergency lights and sirens and obvious efforts to stop the Kia, which exhibited a particular license plate, its driver elected to flee and attempt to elude. Trooper Valentine's marked vehicle was a Dodge Charger painted in a unique and traditional Florida Highway Patrol black and tan paint scheme, and it had agency insignia and jurisdictional markings prominently displayed on its exterior. During the pursuit, Trooper Valentine provided the Kia's number to the Tallahassee Regional Communications Center, who informed him the Kia had been reported stolen. The Kia had been reported stolen out of the Pensacola Police Department by its owners. The pursuit eventually continued southbound onto State Road 123. Trooper Valentine's radio traffic testimony and video evidence captured by his in-car camera system confirmed the Kia was traveling at speeds between 140 and 150 miles per hour in a posted 65 mile per hour zone for significant portions of the 5.4 mile long pursuit. After passing multiple vehicles on the shoulder of the road at high speeds, The Kia eventually traveled into the median of State Road 123. After traveling southbound in the median for 551 feet, the Kia re-entered the southbound lanes, rotated clockwise, and entered the western shoulder. The Kia then overturned for 360 feet before coming to final rest in the southbound travel lanes, exhibiting extensive damage. During the overturning sequence, all 5 of the occupants were ejected from within the Kia. As part of the PSI, the state probation reached out to Trooper Valentine and also to Sergeant Kelly. Sergeant Kelly responded and stated that the defendant and the passenger of the vehicle were members of the LOB gang, which operates largely out of Okaloosa County, and they were fleeing in the stolen vehicle with a stolen firearm and narcotics at a speed of over 140 miles an hour. He stated the defendant was unremorseful and lied about driving at the time of the crash. The PSI, in their interview with the defendant, indicated that the defendant appeared to be unremorseful about the circumstances. That's the Department of Corrections in their PSI. The PSI goes on to discuss circumstances regarding a few social media posts which involve pictures of the defendant flaunting stolen merchandise inside the subject car while holding the stolen firearm and driving erratically that they discovered during the PSI or that were available as part of the discovery during the criminal case. Now, the court understands that the defendant has produced evidence under 921-026, 0026, I believe, sorry, suggesting that a departure is appropriate. And by the way, I need this score sheet, please. Non-public areas, defendant's exhibit A. Yes. Yes. And the court does find that the defense has met the standard to demonstrate that the court has the ability to depart. But the second part of that test is whether the court should depart. And after seeing the demeanor of the defendant here today, reviewing the addendum of probable cause, reading the PSI, reading carefully Dr. Harper's report, including her interaction with him, the court determines that it's not appropriate to depart under the circumstance it presented in this case. And the court finds that, particularly in light of all of the circumstances presented, that the state's suggestion of a 10-year sentence is more than an offer of grace to the defendant, and the court will sentence the defendant to 10 years in state prison in this case, credit for time served. And then that would also be on the other charges, it would be, that's on the principal charge, and then it would be 60 months on, let me check the information. Right, it would be 60 months on count 1, count 3, I apologize. The court's confused as to where we are with all the counts, Mr. Gomez. Are we still proceeding on all 11?
No, Your Honor, there was a plea to, hold on, I have this on the page. For count 1, so the plea was to count 1, 2, and 3, 6 and 7, and then I believe 10.
That's right.
And so we no crossed 4, 5,
That's right.
8, and 9.
So on count 1, it's the 10 years. Count 2, it's the 10 years. Count 3, it's the 10 years.
And then 6 and 7 should be 5.
6 and 7 be 5 years. Count 10, it'd be 1129, and count 11 would be 5 years concurrent.
I don't think there is an 11. We ended up, on the day of the plea, I believe, we had a discussion with the clerk about there not being a count 11. Is that correct?
Say again?
I believe on the date of the plea, we originally had 11 in there, and then the clerk notified us that there actually wasn't a count 11, and it was just and so we didn't address that, if I'm not mistaken.
So right, Madam Clerk?
That would be correct, Your Honor.
Okay, so it's just count 10, Mr. Nopes, you agree?
Yes, sir.
So count 11, so it would be 10 years count 1, 10 years count 2, 10 years count 3, concurrent, count 6, 5, count 7, 5, and then count 10, 11, 29, concurrent.
That's correct, Your Honor.
And fees and costs, Madam Clerk, I think they were covered properly in the plea agreement, weren't they?
I'm checking, Your Honor. No, it doesn't look like they were, but let me check for you.
All right, what would the proper fines, fees, and costs be then, Madam Clerk? And Mr. Nopes, you were appointed or privately retained?
Appointed.
Yeah, so it'd be the, what we're only sentencing today on the 21 case, correct?
That's correct.
So that would be $100 state-provided legal, $150 state-provided legal assistance on that count, on that case, and
So this, Your Honor, I want to say it's 548.
$548 in court costs. And there's the PSI for all, for the 21, in that case, just going to the 21 case.
Your Honor.
And there's the score sheet, yes.
Your Honor, I represent Mr. Levitt on the VOP cases, 20 CF 2870, 2869, and 2867. We've reached an agreement with the state. Do you want us to do that today or bring him back?
No time like the present.
All right. So I'll get that written up, Your Honor, and I'll bring him back out.
Judge, back to my case, it's, all those sentences are concurrent, right?
Correct.
With credit for time served.
Credit for time served.
Thank you, Judge.
Thank you, Judge. While he's writing up that agreement, I'm going to get the score sheet, because the way the timing of the two is a different score sheet for the three VFTs, Your Honor.
Okay, so, but I've already got the court score sheet for this one.
That's the two.
Okay, so you're saying a different score sheet? All right. Who else is ready on the 2 o'clock?
You can take it back. I need to talk to you.
Okay, then.
Let me go talk to him real quick.
Finish that, just
Hi, Judge.
Good afternoon.
Good afternoon. I have David Nicometto.
Yes.
Judge, this is a 3850 evidentiary hearing. However, we have a negotiated resolution, and I have a plea form, Judge.
All right.
May I approach?
Granted. Okay, thank you. All right, go ahead and announce the terms and conditions.
You're talking to me, Judge?
Yes, I apologize.
All right.
I know we do it different every different place, and here we announce the terms and conditions. Do you need it back to do that?
No, Judge.
Okay.
So there were 31 counts. Count 31 is going to be null prost as previously. The first 1 through 15 is going to be a 9-year prison sentence with all credit he's already served. And then the remaining counts, 16 through 30, will be 117.45 months sex offender probation following the 9-year prison term.
And that's the state's agreement.
Yes, Your Honor. Matt Casey for the State Attorney's Office. That is the state's agreement.
All right. And this disposes of all the claims for relief under the pending motions and the fact that we've set it for an evidentiary hearing today. Is that your understanding?
Yes, Your Honor.
And that's your understanding as well for the defense?
Yes, Judge.
Okay. All right, Mr. Nicometto, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Okay, and you can put your hand down. Now, you heard what your lawyer just said and tendered me this new plea arrangement, right?
Right.
And did you sign that?
Yes, sir.
And how old are you?
42.
And how much school do you have?
I have all the way through high school.
All right. You able to read and understand the plea form?
Yes,
And did you do that just now before you signed it?
I did.
And I know it's kind of a new development because you weren't here for this today, but have you had an adequate opportunity to talk about this with your lawyer and to read and review the terms and conditions of this plea agreement with your lawyer?
Yes, I did.
Okay. And it's what your lawyer just announced to me, what you read in this plea agreement?
Yes.
Okay. Now, it's kind of an unusual set of circumstances. Ordinarily, we'd be taking these plea agreements at the beginning of the case, you know, but you've already had the case disposed of once, and you're back here challenging what happened based upon your claim of ineffective assistance of counsel. And this plea agreement is intended to do away with that challenge and substitute this new agreement for the old agreement. Is that what you understand?
Yes, sir.
Okay. And this new agreement provides that the last count, count 31, is null prost, and counts 1 through 15 will be sentenced to 9 years in the Florida State Prison, and then counts 16 through 30 will be 117.45 months of probation on the sex offender level of probation, which includes, looking at the progress docket, I believe all those other conditions were previously stated as part of your original plea, which talks about the designations and the requirements of registration and the discussions that ordinarily you would have that says that affects where you can live, who you can be around, maybe where you can work, the fact that you've got to report your addresses and your phone numbers and your driver's license and your tags and all those other kind of things that go along with that. You understand that?
Yeah. Yes, sir.
This plea is a plea of no contest to all of those charges. Do you understand what that means?
I think I do.
Okay. Well, I'm going to tell you what it means to me, and let's see if we can agree to that. A plea of no contest to me means that you believe on these charges that the state has the evidence necessary to convince the jury of your guilt on these charges, and you do not intend to contest that.
Okay.
Is that what you
Yes, sir.
think a no contest plea means? Do you understand that by making this plea, you're waiving your right for that trial by jury, where you'd require the state to present that evidence to the jury and convince the jury of your guilt beyond a reasonable doubt?
Yes, sir.
Okay. So by making this plea, you're pleading no contest, agreeing that the state has the evidence, and waiving your right to a trial where the state would have to produce that evidence and prove it to the jury. Do you understand that?
Yes, sir.
And we've discussed what the sentence would be, which is the 9 years in state prison on counts 1 through 15, followed by the 117.45 months of probation, sex offender level. Is that what you understood?
Yes, sir.
Now, have you had an adequate opportunity to talk to your lawyer about this plea arrangement and have them answer any questions regarding the plea arrangement?
Yes, sir.
Particularly regarding how this plea arrangement impacts your claim of ineffective assistance for counsel, which this plea is doing away with and replacing the original plea agreement.
Yes, sir.
Have they answered all your questions about that?
Yes, sir.
Okay. Are there any questions about this plea arrangement and how it impacts your claim that have not been answered that you need a moment of time with your lawyer to have your lawyer answer?
Not right now, no, sir.
Well, is there something on your mind that you're worried about because when you say not right now, that's kind of magic words for a judge to hear. There's something that's bothering you. I'll give you more time. It's important that you have the time to have all your questions answered, because as you know, the only way you can make a free and voluntary decision is if you know and understand what you're doing. So if there's a question that's unanswered, I'll put this obnoxious noise on and you can ask that question and get it answered.
Okay, yes, sir.
Okay. All right. Have now all your questions been answered?
Yes, sir.
Okay. All right. And with that, are you satisfied how you've been represented both in the 3850, the claim for ineffective assistance, and now this substituted plea agreement that you've reached?
Yes, sir.
Okay. The court will find the plea to be freely and voluntarily entered into, and will accept the plea with the adjudication with the 9 years Florida State Prison on counts 1 through 15, 117.45 months of sex offender level probation on 16 through 30, and the state announces a null pros on count 31 as a result of this plea.
Yes, Your Honor.
Count 31 is null pros. Any score sheet objections?
No, Judge.
Okay. All right. Thank you very much.
Judge, I don't know if you announced it. Did you announce he gets all prior credit?
Yes, it says credit for all time served. I apologize if there's any.
Thank you.
I'll write on there clear that it's credit for all time served.
Thank you. And he can be sent to DOC as soon as possible, Judge?
Yes.
Thank you.
There's nothing else holding him, is there? That
No,
we're
Your
aware
Honor,
of?
no, Judge.
Bailiff, anything else that you're aware of that's holding him? Not that I'm aware of.
Thank you.
Thank you very much. And have a safe journey home.
Yes, sir.
Thank you.
Yes, since they've already been paid, and we'll just make a note of that.
He's ready, let's do it, because they want to break it. Okay.
All right. Who's next?
Jerry Bowman, please, Your Honor.
Bowman, please.
Yes.
You know, this is going to be a plea in a moment for signatures.
Yes, sir.
Your Honor, Mr. Jerry Bowman on case number 21 CF 0555. Your Honor, today my client has, we've entered an agreement to admit the violation in exchange for the admission, it will be a revoke and terminate, 60 months Department of Correction with credit for all time in Okaloosa County Jail, which I've calculated to be 621 days, plus credit for 18 months served in Texas with court costs, cost of prosecution, and cost of defense. I need you to initial right here because I made a change, okay? Because you've already been adjudicated, so. And I have the signed plea form and the score sheet. On the front of the plea form, Your Honor, it was accidentally marked as adjudication withheld. I made the change and I had my client initial it to verify that it was done.
All right. All right, raise your right hand, please. You swear or affirm, testify truthfully in this matter under the penalties of perjury.
Yes, Your Honor.
All right, you can put your hands down. You heard what Mr. Cochran said, you signed the written plea form.
Yes, Your Honor.
You understand that you're admitting the violation.
Yes, Your Honor.
And by admitting the violation, you're telling me that you agree that you violated your probation just the way your probation officer says you did.
Yes, Your Honor.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove it?
Yes, Your Honor.
You'll be adjudicated guilty, sentenced to 60 months in the Department of Corrections, credit for all time served, which includes the 620 days in the county jail and 621 days in the county jail and the 18 months you served in Texas.
Yes, Your Honor.
And then you'll have the outstanding fees and costs, which were discussed, $100 cost of prosecution, $150 state-provided legal assistance, and I'll give you 24 months after you get out to pay. Okay?
Thank you, Your Honor.
Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, Your Honor.
Satisfied with how he's represented you.
Yes, Your Honor.
Find the pleas freely and voluntarily entered into and accept the plea.
Thank you.
You want me to copy that?
All right?
Your Honor, may I be excused?
Yes, ma'am.
Thank you.
All right, so I'm showing, Trevor Brown is removed from the docket, right?
Should be, yes,
So
Your Honor.
that leaves us with Julie Glover and Jennifer Lample, is that right?
And we also need to resolve the rest of Mr. Lovett's cases, the VOPs.
All right. Did we miss something on your case, sir?
My bag.
Oh, we thought you were contributing to the cause. Safe journey home.
Thank you. Yeah, I'm trying to write it up. How do you do other things too?
Good afternoon, Your Honor.
Good afternoon.
Joseph Riasti for Julie Christine Glover, who's present before the court in 2019 CF 2431.
Yes, sir.
This case has been set for an evidentiary hearing with regard to Ms. Glover's 3.850 motion for alleging ineffective assistance of counsel on the
Yes,
part
sir.
of Jason McKinney, who's present before the court.
Yes, sir.
Also, and we'd like to proceed on the defendant's motion at this time.
Yes, sir. Go ahead.
If I might, if we could do it from the,
Say again?
do you want to have, well, I can do it from here. I'd call,
Well, please sit at council table so you can spread out and be comfortable with your client, sir.
the defense would call Jason McKinney.
Jason McKinney.
Is Jason out there, Molly? Is Jason out there? Yes. Can you grab him? I'm saying you're on.
All right, Mr. Finney, raise your right hand. Madam Clerk, swear the witness.
You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please be seated, Mr. McKinney. You may inquire.
Mr. McKinney, were you assigned this, the case 2019 CF 2431 to defend Miss Julie Christine Glover in 2019?
Yes, I was the attorney of record.
And was there a point in time that you filed a expiration of speedy trial and a demand for speedy trial?
Yes.
The record shows that it was on February 24th, 2020. Would you dispute that if that's what the record showed?
No, and I would assume that the record is correct.
Had you, had the state filed an information at that time?
You'd have to rely upon the record. I believe so.
Actually, the record shows that the information was filed January 27th, 2020. So
That sounds accurate.
did you have a discussion? Was Miss Glover incarcerated at the time, or was she on bond?
I do not remember. I remember that there were a few periods of time where she had other cases going, where she may have been incarcerated for a period of time, but I don't remember.
Did you explain, did you have a chance prior to, well, there was a point in time where Miss Glover waived her right to speedy trial. Is that your recollection?
Correct. I believe that would have been on March 4th of 2020 at docket day.
March 4th of 2020. And her motion states that it was March 4th, 2020. Is that your recollection?
Yes.
Prior to March 4th of 2020, did you have a chance to explain to Ms. Glover the elements of the crime that she was charged with, the crimes that she was charged with?
Yes.
And do you recall what she was charged with at the time?
She was charged by information with 2 counts, one of which was driving while license suspended, or driving resulting in death with careless or negligent operation, and a second count of driving while license suspended or revoked.
And both of those were third-degree felonies?
Correct.
Did you explain to her the maximum penalties involved with regard to, for both of those charges?
Yes.
Do you remember if you explained to her, what was, can you go walk through your discussion with Ms. Glover with regard to what would happen at jury trial? What did you explain to her what would happen at jury trial if you proceeded to trial? Do you recall what you told her?
That can be a very long answer. But if we're going to talk about everything that could happen at trial, I can say that Ms. Glover was very involved in her case, and we were able to sit down and discuss the pros and cons of potentially going forward with a jury trial.
Well, let me ask this. Did you explain to her the elements of operating a motor vehicle without a driver's license in careless or negligent fashion resulting in death?
Yes.
Did you explain, was there a time when Ms. Glover believed that the state couldn't based upon her driving record, that the state couldn't prove that she was operating the motor vehicle without a driver's license, that element of the crime.
Can you rephrase your question, because it calls for what Ms. Glover believes?
Did Ms. Glover state to you, prior to her waiving speedy trial, that she believed that the state couldn't prove that she was operating a motor vehicle, the element of that she was operating a motor vehicle without a driver's license because her driver's license was only expired and not revoked?
I don't remember that specific conversation.
Okay.
But yes, her driver's license was expired. And ultimately count two, or I believe count two, which was a third-degree felony, was null pros by the state. And that count was the driving while license suspended or revoked.
On March 4th, what was the reasoning in which you asked Ms. Glover to waive her right to speedy trial? Was there a plea agreement that had been offered by the state at the time?
There had been no plea agreement specifically offered at the time on March 4th, which was docket day. The conversation that took place with Ms. Glover was explaining the different options on how we could proceed forward so that she could make a decision. At no point did I tell her that she had to waive her right to speedy trial.
All right. Did you ever, in that conversation, explain to her that there was a benefit to waiving speedy trial and that it would benefit plea negotiations?
Yes. The state had indicated that they would open the door to negotiations, and we had the discussion related to, do we leave this case set for trial and pick a jury on March 9th and have a trial on the week of March 16th, or do we waive speedy trial, continue the case to open the door to negotiation with the state?
Did you promise her that anything in regard to the plea negotiations at that time?
No.
Did you believe at the time that the state could prove all the elements of operating a motor vehicle without driver's license in careless or negligent fashion, resulting in death, that there was a chance that she could lose at jury trial?
Absolutely.
Did you explain, and you explained that to her prior to her waiving speedy trial?
Yes.
Do you recall any specifics with regard to that particular conversation?
I remember reviewing the crash report, which included a statement that I didn't mean to hit her, that was made by Ms. Glover at the time, which I thought was a turning point in a potential trial on whether or not a jury would believe she was operating in careless or negligent fashion related to the traffic crash. This case had been fully prepped for trial if she would have elected to go forward with the trial.
At the time, was there any chance that statement could have been suppressed? Was there any discussion regarding a motion to suppress that statement with Ms. Glover specifically?
I don't recall any specific conversations related to a motion to suppress on that one specific statement.
Do you recall what, if if Ms. Glover made any statements as to why she, with regard to whether or not she wanted to waive speedy trial at the time.
On March 4th?
On March 4th, specifically.
On March 4th, the case was called, and there was discussions that was captured by the record at the podium, in which case there was a point in time where we stepped out into the hallway and had discussions on whether or not we should proceed forward with trial, or whether or not she wished to waive her right to speedy trial, continue the matter in hopes that we could negotiate the matter with the state to try to get the least amount of sentence possible. And to answer your question specifically, the end of that conversation was that she wished to waive her right to speedy trial and try to negotiate the best result with the state, which is exactly what we walked back in the court and said.
How much time did she have to make that decision at the time?
I didn't carry a stopwatch, but I would always afford any client as much time as they ever needed to make a decision.
If there was a time when she seemed adamant during that specific conversation, was there a time that you believed that you had to convince her, or did you believe that she reached the decision on her own to waive her speedy trial?
I believe that she reached that decision on her own.
During that conversation, did she mention, prior to your discussion outside of that, either the day before that, in the 24 hours prior to waiving speedy trial, did she express to you a desire to take her case to trial?
I can't answer specifically in the prior 24 hours, but I would have never have filed a demand for speedy trial without having a conversation with my client about whether or not she wished to go forward with trial.
So there was a point in time where she expressed a desire to go to trial?
Correct.
Did she specifically state at the podium there that she wanted to go to trial before that discussion?
At the podium, the record would be the best reflection there.
I have no other questions.
May I proceed, Your Honor?
You may.
Just for the record, it's Matt Casey with the State Attorney's Office. Let me ask you, Mr. McKinney, specifically regarding the discussion on March the 4th, 2020, about the potential waiver of speedy trial by your client at the time, the defendant, Ms. Glover. Were you present when the judge went through a colloquy to make sure that she understood what right she was waiving and that it was, whether or not it was her choice?
I was standing right next to my client.
Okay. And that did occur?
Yes.
And do you recall what she said?
I do not recall specifically what she said. The record would be the best reflection.
Okay, fair enough. And I know you already testified when asked by Mr. Riasti that you didn't make any promises to her regarding plea negotiations. Would it be fair to say that, what you told her is that there were no guarantees that you'd be able to get a specific plea offer from the state, but by continuing it, it would allow that dialogue to continue?
The state in court on March 4th had shown a willingness to open the door to negotiations that we had never had before in that case. So we did have that discussion on what would be necessary to negotiate. And I'm dancing around the topic here, but specifically, she had a score sheet that related to death points, which could arguably be discretionary to the state attorney. And the state attorney's office could choose to negotiate by dismissing one of the counts, which they did, or they could agree to a downward departure. There were different avenues for negotiation that we could explore, and I did explain those to Ms. Glover prior to her making her decision.
Okay. And did you feel like she had any problems understanding you that day?
We had a normal conversation, and I did not believe that there were any points that she did not understand what I was saying.
Okay. Was this around the time, again, this has been the discussion we're talking about, again, March 4th, 2020 for the record, was this around the time the COVID pandemic hit and affected the courts?
Yes.
And do you recall, I guess, as best as you remember, was there a period of time shortly after that conference or that court date with the defendant where in fact there were no jury trials?
Correct. I believe with the Florida Supreme Court order canceled all jury trials starting on March 16th and told all speedy trial. And that was the official response from the Florida Supreme Court. However, most of the people who worked within the court system anticipated that something like that was going to happen. And I recall specifically that that was part of the conversation with Ms. Glover, that there was a chance, even with us, if we chose to go to trial, we might not get to a trial.
So again, that would have been part of the equation or discussion with Ms. Glover as to why it might be a good strategy to agree to a continuance and see if you could further negotiate the case.
That was part of the dynamic, yes.
Okay. Is there anything else you can think about that we haven't already discussed, any other information the court should know regarding the defendant's allegations that, again, we haven't already covered?
No, sir.
Okay. That's all I have. Thank you, Your Honor.
Redirect?
No, Your Honor.
The witness excused.
The defense would call Julie Glover.
Is the witness excused?
Yes, Your Honor.
Okay.
No objection.
All right.
The defense would call Julie Glover.
All right.
This is more progress.
All right, remain standing, raise your right hand as best you can. Madam Clerk, swear the witness.
You swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Yes. Thank you.
Please be seated. Mr. Riosky, you may inquire.
Ms. Glover, do you recall the events on March 4th of 2020?
Well, I didn't know that that was the date, but I do recall having a conversation with Mr. McKinney.
So at that time, is it your understanding that you needed to decide whether to go to trial or to continue the case? Is that your understanding?
Yes. I was sitting in one of those pews, and he said, "I need to talk to you," in the hallway. So we went out there, and he said, "I would like to take this case in a different direction." And I said, "Well, what do you mean?" And he said, "This case has been going on for over a year." He said, the court hearings, out of the 18 of them, I mean, that's a lot. He said, they're just ready to get it over with. And he said, we could waive your right to a speedy trial. And he said, if you do that, he said, you could possibly get an offer from the prosecution. She might offer you a deal. And I said,
Did
oh.
Mr.
and I said, okay.
McKinney promise anything at that time?
Not a promise, but led me to believe that I would get a deal from the prosecutor if I waived my right to a speedy trial that day.
Did Mr. McKinney, what was your understanding of what would have happened if you took your case to trial? Did you have a conversation with Mr. McKinney?
Yes, I do. I don't remember where we were at, because I've been to his office several times, and he was explaining things, and he told me I could get you a downward departure. That was at one of the meetings at his office, and then I was like, great, that's really good. Never got back to me on that. Another meeting I had at his office, he said, there's no really evidence, there's no evidence against you, there was no witnesses, there was no video camera, and he said that the traffic investigation has stated that because I was not under the influence, I've never had a DUI, and that in fact, the victim had hit my car. And that he told me she had pedal confusion. It showed me an 8x10 picture of the shoe that was lodged between her brake and her gas pedal. And so I was hopeful in that either I was going to win at the speedy trial, or if I didn't do the speedy trial, that I would get an offer from the prosecution, and none of that happened.
So what was your intent on March 4th? Was it with regard to jury trial?
Well, I was hopeful that if I had went to a trial, it would go good, everything was going to go fine, but if it did not, then I was going to get an offer from the prosecution. And then, so I waived my right that day, thinking and hoping that I would get some kind of deal from the prosecution. And that's the only reason I waived my right.
Did you have enough time do you believe you had enough time to consider waiving speedy trial?
No, it happened that day. I said, it was at that hearing, and I said, well, give me a pen. He said, it'll make her happy. And I remember this statement he said, we could be the bigger person here. You could be the bigger person, Ms. Glover, and, that would benefit you. And you could get an offer from her. And I said, okay. Well, I said, give me a pen.
Do you think that those statements amounted to a promise of a downward departure?
One of those, either a deal from the prosecution or a downward departure, yes, and yes, I do. And I was hopeful.
Was it, so I'm asking you specifically, do you think that Mr. McKinney promised you a downward departure, or did he say a downward departure was possible?
Not promise, but he said, I can get you. And he told me a story about a man that he had helped in Panama City. He had told me a case he had, that this man had hit, and he was drunk and had hit a female, and I can't remember if she either died or she was in ICU, but he said, I got him 5 years probation, so I'm pretty sure I can get you either probation or downward departure or something, but not prison time.
Do you recall did the court ask you questions regarding your waiving of your right to speedy trial?
Just asked me if I understood.
And what was your response to the court?
Yes.
Do you believe you voluntarily waived your right to speedy trial, or you were coerced?
I believe I was coerced. Not in the sense that you should do this. I was coerced in that, believing that something else was going to happen if I waived my right to a speedy trial. I thought I was going to get an offer from to my attorney or my public defender, Mr. McKinney, by the prosecution.
I don't have any other questions, Your Honor.
Good afternoon, Ms. Glover.
Good afternoon.
So you didn't express any hesitation to the judge about waiving speedy trial when you were asked, did you?
No.
You didn't ask for more time to talk to Mr. McKinney, did you?
No.
You understood that by waiving your speedy trial that day, that you were not going to have a trial March the 9th or March the 16th, correct?
Right, correct.
And again, I think your words are, I was thinking and hoping to get a deal. I was hopeful, correct?
Mm-hmm. Yes.
That's all I have, Your Honor.
Redirect.
No, Your Honor.
You can step down.
Thank you.
Anything else, Mr. Riasti?
This is an evidentiary hearing. I could make argument with regard to her motion.
Any other evidence you
No, Your
wish to
Honor.
put on?
No, Your Honor.
Any evidence for the state?
I have no witnesses, Your Honor. I would be asking that the court take judicial notice of the court file, which contains the transcript of the March 4th, 2020 hearing, as well as some of the other transcripts.
No objection to that request, Your Honor.
Court takes notice. Do you have some specific designations you wish for the court to take notice of?
Nothing specific really, other than I guess the March 4th, 2020 transcript, which was, looks like about 8 pages, Your Honor. I do think that's relevant, and I might be referencing it during my argument.
All right. All right. So arguments now. Mr. Riasti?
Your Honor, Ms. Glover believed, and she stated on the stand that she believed that she was not guilty of the offense of operating a motor vehicle without a driver's license in careless or negligent fashion resulting in death. In that there were specific facts that she was told before her waiving of the speedy trial to indicate that she would be victorious at trial. And that was her understanding at the time that she waived. And it was her testimony that her defense attorney, Jason McKinney, put undue pressure on her in a short amount of time to make a decision to waive her right to speedy trial with what she believed amounted to be a promise of a downward departure based upon his statements and the story that he told, so that in aggregate, she believed that Mr. McKinney was promising her a result if she waived speedy trial, a specific result if she waived speedy trial, which I believe is improper and amounts to ineffective assistance of counsel.
Be passed to the state?
Yes.
May it please the court, counsel? Your Honor, I think it's relatively clear from the record. The court put Ms. Glover under oath starting at line 9, page 7 of the transcript from March 4th, 2020. She was sworn in. She answered yes to telling the truth. The court said, you can put your hand down. You've heard all of the discussion about your right to speedy trial. Defendant responded yes. Court said, and generally a defendant does that to force a case to trial. Now, do you understand you've announced that you're waiving that and withdrawing your notices? Defendant said, yes, sir. Court said, and as a result, the trial which we had scheduled to pick a jury is no longer going forward. It's going to be set on the next trial cycle, which the dates are in the notice that Mr. McKinney is going to give you. Do you understand that? Defendant said, yes, sir. Court said, is that what you want to do? Defendant said, yes. Court said, the court finds a free and voluntary waiver. Then Mr. McKinney said, and Judge, we will continue working with the state to make sure that we're on track for that. And then the court said, very good. Defendant said, thank you, Your Honor. And the court said, "Thank you, good day," and the proceedings adjourned. And that ends on page 8 of the transcript. I think it's pretty clear from the testimony, both from Mr. McKinney and from the defendant, that first of all, Mr. McKinney was not ineffective in this instance because of, number one, he knew COVID potentially was going to shut things down, which ultimately it did, that it might be a good idea strategically to waive Speedy at that point and to, hope that that would, for lack of better words, curry some favor with the state. Ultimately, she did get some benefit of that because, as Mr. McKinney testified, one of the 2 charges was dismissed. As a result, that lowered the score sheet total, at least some, and ultimately that's what she was sentenced to. And I think, obviously, in this instance, the reason we're here today and the reason the ineffective assistance claim was made, the state would submit, is because obviously the defendant was disappointed with that outcome. And I think that's reflected by her testimony today when she said, by waiving it, I was hopeful. I was thinking and hoping I'd get a deal. But that's exactly what Mr. McKinney explained to her, was there's no promises. Certainly, I think that hope in her mind, put her in a perspective that she was going to get some magical plea offer or some departure sentence. Unfortunately for her sake, that didn't happen. But again, that's, Mr. McKinney, I would submit, did not make any promises that he testified to today, nor really from the defendant either, about what was going to happen if she waived Speedy. And the reality is that she did get some benefit by having the 1 count dismissed. So I think the case law is fairly clear that if it's a strategic decision, plus in this instance, not only can I argue it was a strategic decision to waive Speedy, but in this instance, we've got a very thorough colloquy from the court, where there's no hesitation, there's no mention by the defendant that she needed more time to discuss it with Mr. McKinney or she didn't understand. I mean, the answers are very clear and straightforward on the record. Again, I thought it was important to have a hearing today just to have it fleshed out with Mr. McKinney for record purposes, as to what he did tell her leading up to the waiver. But I think coupled with that testimony and the transcript itself, and then as well the defense testimony today, I think it's very clear there were no promises, and in no way have they met their burden of showing that the outcome in this case is undermined because there was any sort of ineffective assistance of counsel by Mr. McKinney. I think Mr. McKinney did exactly what good defense attorneys do. They try to work hard for their client. Unfortunately, the outcomes aren't always what the client wants, certainly, or even what the attorneys want. But there's nothing he did here that I don't think they can say that no reasonable attorney would have adopted this same strategy. I think it was a reasonable strategy, particularly considering the Supreme Court order that essentially shut down the courts very shortly thereafter. And it did yield some positive results for the defendant, certainly just not as much as she had hoped. So based on all of that, the state would be asking the court to deny the motion. Thank you.
Rebuttal argument.
No, Your Honor.
The court will review the complete record and the testimony here and its notes, and will provide you with an order.
Thank you, Your Honor. May I be excused?
Yes, sir. Good day.
Thank you, you too.
That's all I have before your court, Your Honor.
Thank you. And Ms. Glover may be transported back.